Good afternoon, everybody. Attorney General Martha Coakley, I just want to introduce who's here with me today. I'm going to turn the microphone over then to the U.S. Attorney Michael Sullivan. And on my right, starting on my right from the U.S. Attorney's Office, Assistant U.S. Attorney Jeff Cohen, Assistant U.S. Attorney Fred Wyshak, the Special Agent in charge of the FBI, Warren Bamford, and to his right is the Special Agent in charge of the Department of Transportation from the Office of the Inspector General, Ted Doherty. Behind me is Michael Sullivan, Special Assistant Attorney General Paul Ware, assigned to this matter. Standing in for Mark Delaney is Detective Lieutenant Dennis Brooks. And we have also the Secretary of Transportation of the Commonwealth, Bernard Cohen, and to his left is the Executive Director of the Mass Turnpike Authority, Alan Lebovich. Michael?
Thank you, Martha. Good afternoon. I guess you must all know why we're here this afternoon, but we are here to announce that an agreement has been reached between the United States, the Commonwealth of Massachusetts, and the management consultant to the Central Artery Tunnel Project, which obviously is known as the Big Dig, as well as several of the Big Dig designers. The Big Dig management consultant, Bechtel Parsons Brinckerhoff, Bechtel Infrastructure Corporation, and PB Americas, Inc., has agreed to pay the United States and the Commonwealth over $407 million to resolve criminal and civil liabilities in connection with the collapse of part of the I-90 connector tunnel ceiling and defects in the slurry walls of the Tip ONeill tunnel. An additional $51 million will be paid by several of the designers on the Big Dig to resolve certain cost recovery issues associated with the design of the Big Dig. A total of over $458 million will be covered by the United States and the Commonwealth of Massachusetts. The majority of this money, approximately $415 million, will be held in a special account dedicated to the long-term repairs and maintenance of the Big Dig structures for any conditions not caused by ordinary wear and tear. It's important to note that this agreement does not release Bechtel Parsons Brinckerhoff from liability for any future catastrophic events that occur within the next 10-year period, nor for any non-covered conduct. The agreement, as you'll read, includes a catastrophic event clause which is triggered when damages from a single event exceeds or may exceed $50 million, in which case the government can recover up to $100 million in damages per event. Today, among other omissions, Bechtel Parsons Brinckerhoff acknowledges their role in the breach of the slurry wall, as well as their oversight failures in three other principal areas: the anchor systems in the I-90 connector, overcharging and overpayment of time and material by the major contractors, and quality assurance failures, particularly with the major concrete supplier. For example, our investigation revealed that approximately 230 concrete slurry wall panels were constructed on the C-17A1 between 1998 and 2001. A review of this evidence revealed a systematic failure to meet contract specifications, including slurry applications, before concrete was placed. Nonetheless, Bechtel and MCC executed certificates of beneficial occupancy indicating that the Massachusetts Transit Authority or a third party could safely occupy the area. Certificates of beneficial occupancy and a substantial completion certifying that the I-93 tunnel was safe were also not true or accurate. Bechtel knew that some of the slurry walls in the tunnel were not built according to contract specifications. Other requirements detailed in the agreement are as follows. Bechtel and Parsons Brinckerhoff are required to enact corporate compliance agreements. Bechtel Parsons Brinckerhoff must conduct an internal investigation and report to both the federal and state governments if the investigation reveals any material construction defects. They have 180 days to submit that report to the government. As mentioned, the agreement addresses the conduct of Bechtel Parsons Brinckerhoff in 4 different areas. First, Bechtel Parsons Brinckerhoff has acknowledged serious failures in its obligations to manage construction of the I-93 slurry walls. They acknowledge certain failures regarding its oversight responsibilities concerning the construction of the ceiling in the portal area of the I-90 connector tunnel. They also acknowledge failure to adequately fulfill their construction management obligations relating to contract modifications. And lastly, Bechtel Parsons Brinckerhoff has acknowledged its failure to meet its oversight obligations with respect to the delivery and use of non-specification concrete in big dig structures, including I-93 mainline tunnel slurry walls by Aggregate Industries Northeast Region, Inc. Massachusetts Highway and the citizens of Massachusetts entrusted Bechtel Parsons Brinckerhoff to act as their eyes and ears on the Central Artery project. They grossly failed to meet their obligation and responsibilities to the citizens of Massachusetts and the United States. The investigation that led to today's agreement was commenced after there was a breach in the slurry wall panel in the I-93 mainland tunnel in September of 2004. Our Big Dig Task Force has now charged 9 individuals in one company and have recovered in excess of $500 million. Today's settlement and compliance agreement with Bechtel Parsons Brinckerhoff is continuing evidence of our commitment to vigorously investigate and prosecute those who have perpetrated a fraud on the taxpayers. It's critically important that federal and state tax dollars needed to fund important public works projects like the Big Dig are safeguarded against waste, fraud, and corruption. The fact is our work is not done. As we've said in the past, we will dedicate the resources and time necessary to complete a comprehensive review and investigation of the Big Dig project. I can assure you that no stone will be left unturned. I want to commend the task force established in 2004, which includes the Department of Transportation Office of Inspector General, the Federal Bureau of Investigation, the Massachusetts State Police, Department of Labor, Office of Inspector General, the Massachusetts Attorney General's Office, and the United States Attorney's Office. They have done and continue to do a phenomenal job under very challenging and difficult circumstances. I'm going to turn it back to the Attorney General, Martha Coakley.
Thank you, Michael. I want to echo what Michael has just said. First of all, that in my experience, and I believe in the U.S. attorneys, this has been an unprecedented collaboration on behalf of the citizens and the taxpayers of Massachusetts. We have worked together on a very complicated and complex issue for hours and months, longer than maybe we had hoped, but certainly to reach a result today that we believe is in the best interest of the Commonwealth and the federal government and those others who were affected by this. As we've worked to resolve this, however, we have been ever mindful that Milena Del Valle lost her life in the tunnel on July 10th of 2006. We believe that today's global agreement is the best possible resolution, and I do not say perfect, but it is the best possible resolution at this time for the Commonwealth, for the federal government, and for others involved. The agreement allows us to resolve criminal and civil claims, to provide for future repairs, and to ensure the future safety of the Big Dig tunnels while we still honor her memory. Let me tell you that when I became Attorney General just a year ago, we tackled a huge and somewhat overwhelming investigation to determine whether we could resolve the facts and reach a resolution around the Big Dig. That, of course, is shorthand for what is a much more complex set of legal and factual issues involving public and private parties, and the enormity of it is belied by the shortness of the name for this project. There was civil cost recovery against a variety of parties. There were pending criminal complaints, future contingencies about providing for and determining what were the flaws in this project, how are we going to pay for them. All of these we set to work with the staff in this office, begun work by my predecessor, Tom Riley, working with the U.S. Attorney's Office and the incredibly dedicated staff, many of whom are here today, some of whom are behind us, but I cannot tell you how much work and time and collaborative effort was put in reaching today's agreements, which I think when you look at them closely will realize how far-reaching they are.